My lords, in 1996, my lords, in the general elections to the UP Legislative Assembly, no political party obtained an absolute majority case. So there was an agreement between the Bharatiya Janata Party and the Bahujan Samaj Party. BSP at that stage had 67 MLAs and the BJP had 175 members in its fold. On 21/9/1997, Mr. Kalyan Singh of the BJP was sworn in as the chief minister. On 19/10/1997, the appellant, that is Avati, announced withdrawal of participation and support of the BSP to the coalition government. All the BSP members resigned from the government. Immediately, the governor of the state convened a special session of the assembly at 11 a.m. on 21/10/97, that date is important, and told Mr. Kalyan Singh to prove his majority on the floor of the house. After that, on 28/10/97, appellant issued a whip directing all BSP MLAs to remain present in the house throughout the proceedings on the next date and vote against the motion. That was the whip issued. On 21/10/97, 222 members of the assembly voted in favor of the government. There was no vote opposing it. On 24/10/97, 13 petitions were filed seeking disqualification of those members of the BSP of violating the whip given on 20/10/97, the whip which had been given. And the petitions invoked only clause 2(1)(b) of the 10th schedule. Your lordships may note that the allegation was 2(1)(b) of the Constitution. On 25/11/97, the concerned MLAs against whom disqualification petitions had been filed their written statements and pleaded that a split took place between the members of the BSP on 21/10/97, and more than one-third legislators of the BSP got separated, and thus they relied on the protection of para 3 of the 10th schedule. The speaker on 23/3/98 dismissed the disqualification petitions and recognized the MLAs as a separate political party. In this background is what the appellant said, and in this background what the appellant said is that it is the whip which is issued by the erstwhile legislature party of the BSP and not the new political party which had been formed, as used in para 2(1)(d), is the legislature party of the original political party of those MLAs is what is to be read into 2(1)(b). The court said nothing doing. Political party, as mentioned there in 2(1)(b), cannot be read as a legislature party. So this was a split, a new party had been formed, and they were bound by the directions of the new party and protected by that.
What were they relying upon in Mayawati in particular? What is the...
That a whip of the legislature party of the BSP of which they were a member before splitting had told them not to vote.
28th October whip.
Yes, had told them not to vote in favor of the motion.
Right.
So they said you violated the whip of the legislature party, and because you violated the whip of the legislature party, you are disqualified. They said we have split and we formed a new party, and our new original political party told us what to do. We did it in compliance with that. So Ms. Mayawati argued that you read legislature party into 2(1)(b), and that whip ought to be obeyed of the old party. The court said, no, we will read it as the political party, and they are protected by para 3 of the 10th schedule. Now, my lords, in our case, there is no rival faction which has split. The rival faction is within the party. No new political party has been formed. The question is not of an erstwhile legislature party of a party that you belong to vis-a-vis the new original political party that you formed. The judgment at no point says that when a whip is whom the speaker interacts with, The whip as appointed as per the rules conveyed by the leader, etc., should be ignored, and we should look at some deeper other whip which the political party is appointed. That's not what it says. All it says is, in the given facts and circumstances, that that legislature whip of the party is not applicable because they are protected by the sanction as given by the formation of the new political party. So Mayawati, according to us, my lords, has no application at all. And in any case, my lords, as I have said, it's never been our case that it's only the legislature party and not the political party. We've right through said both are co-joined, organic, integrated, and any action of the legislature party has the political authority of the political party to say what it says. Now, my lords, Rajinder Rana, Volume 1, PDF page 834.
(834).
Yes. So, Manoj, Rana is relied on by them. I relied for a different purpose. They rely on Rana for two essential purposes. One is that it said disqualification is ex post facto. So everything goes back to the date of disqualification. And secondly, your lordships, in an appropriate case, decided the issue of disqualification as a court of first instance rather than remanding the matter or letting the speaker decide. Those are the two grounds taken to rely on Rana. Now, my lords, just some facts. Quite apart from the second issue, my lords, the straight answer would be the matter was pending for 3 years in the High Court. The High Court then remanded it back. The Supreme Court said the assembly elections are at the end of the year. Rather than remanded, decide the matter. Those are peculiar facts, not that in every case you bypass the constitutional authority and come to the Supreme Court as a court of first instance. But on the first part, my lords, some crucial facts. After the 2002 UP elections, my lords, to the UP State Assembly, a coalition government was formed headed by the Bahujan Samaj Party. In 2003, my lords, the cabinet recommended dissolution of the assembly. And now this is important. Before the resignation of the cabinet, my lords, on 27/8/2003, 13 MLAs of the BSP party met the governor and requested him to invite the leader of the Samajwadi party to form the government, the opposition to form the government. The governor acceded to the request. And thereafter, Mr. Swami Prasad Maurya, who was with the BSP, filed a disqualification petition saying that they had voluntarily given up the membership of the party by supporting Samajwadi party and going to the governor. On 6/9/2003, 13 members, those 13 MLAs who had gone to the governor with the Samajwadi party MLAs, fortified by another 24 MLAs, requested the speaker to recognize a split in the party, and the speaker recognized the split in the party. The Supreme Court said that split and to be entitled to the benefits and protection of para 3 of the 10th schedule is an event which happened later. The governor is only concerned with the day when those 13 BSP MLAs met the governor and requested him to invite the leader of the Samajwadi party to form the government. And the speaker should have only looked at the facts on that day and said not at subsequent events, and in that context said, ex post facto, it will go back to the day they were disqualified or incurred disqualification under the 10th schedule. It could have never been the intent of the court, and it did not say so, that on one hand the Supreme Court says that till disqualifications petitions are pending, you participate in all proceedings. On the other hand, the moment you're disqualified, all your actions are annulled. So ex post facto was specific because the speaker started looking at subsequent events. The speaker started looking at a split which had not happened on that day. And they said this is an overt 2-1A act, where you go to the governor, request him to get the Samajwadi Party to form the government. It was in that context. The other part of Rajendra Rana, I pointed out to my lords that, now my lords, another judgment.
Sir, Paul, why don't you do this tomorrow morning? Just give us in 2 pages a small note on how you distinguish each of those judgments.
Very well, very well, very well,
Much
very well,
quicker,
very well.
isn't it?
No, I'll do that. I'll get for all those 4 or 5 judgments
That's
a
right.
distinguishing note tomorrow.
Just 2 or 3 pages.
Yes.
There's a bullet.
And what I'll do, my lords, tomorrow is I have also prepared a written note of the various propositions and judgments that I'm relying on.
Right.
I'm in the process. I'll take your lordships through that. And wherever your lordships wants me to really read any particular paragraph, I can do that.
All right. That will be much quicker then. Yes.
If
Faster.
just
Now,
to
just so that how long would you take? Will you finish in about an hour or so tomorrow?
yes.
So we target starting by 11 o'clock tomorrow. So 12 if you finish, then between Mr. Jetlani,
What I'm respectfully submitting
if
is,
you can, Mr. Jetlani and Mr. Maninder Singh, if you can give us a brief note of a page or so.
I was about to say that, Malad, to remain within the time discipline, Malad, we'll furnish a note by today evening. And Malad, very 10-15 minutes, Malad, we'll just make your lot.
If both of you can just give us, email the note to the court master, so he'll circulate it in the night to us and give it to Mr. Sibal, because Mr. Sibal will also be then.
Try to finish before.
And you can also email
The
your note to
problem
Mr.
is the
Sibal.
Solicitor General is to argue. Please remember that.
Yes, of course.
So-
Now, what about the solicitor? So maybe, Mr. Kaul, is it possible for you to sort of complete by say 11:45? Say we start at 11 because we have mentioning. If you can try and compress it by 11:45,
Try my
then between Mr. Jetlani and Mr. Maninder Singh by 12:15, that leaves 45 minutes to the Solicitor General. If we can do that, we entirely with.
We'll try our best, as succinct as we possibly can be, we'll try.
Because otherwise
that-
it will be
Right.
difficult.
Well, otherwise, the rejoinder could be
difficult for us.
restricted to 1 hour. They've argued for 3.5
Otherwise
hours.
it will
my
be
lords.
difficult. Well, that's, if they don't finish by 1 o'clock.
Rejoinder already depends upon how the other side is
Then
acting.
1.5.
So how long was the solicitor likely to take? Any idea?
He said 1 to 1.5 hours to me.
So
1 to 1.5 hours to me, he told. He told such.
All right, try and make your arguments as compared. But we'll wrap up with this side by lunch so that, yes.
the first we'll sit down.
No, it's
Within
not
the
like that.
time-
We just,
The one
because-
thing-
only because we are heading
the
towards
one
a
thing-
week-long break, and we don't want to keep this beyond the break. That's
The
the.
one thing the learned Chief Justice is, he never gets tired of anybody. He never shows it, at least.
That's the theory of it.
No, but that's a fact in my mind as well, because,
I
if
know.
you have an understanding about how vast the field of knowledge is, you can never tire of
That's
the
the-
arguments which lawyers were before.
We've
Because the
noticed
last word is never said until the last word is over.
That's correct, that's correct. And I hope we have.
Very
last
grateful,
word.
man. Very grateful.